In this case study, we'll look at the problems that arise on death when using individual SIPP pensions to hold property, and how having a SAS can save clients considerable amounts of time and money when the worst does happen and one of the SIPP holder dies. So let's have a look at the initial scenario. Here we have a commercial property and it's owned by 4 individual SIPPs. The SIPPs belong to a husband, a wife, and 2 grown-up children, so there's already a family relationship in place. However, the issues are the same, or perhaps even worse, if the property were to be held within a single SIPP, as is often the case. But for now, let's keep the property ownership split amongst these 4 SIPPs. Okay, so let's start by looking at what happens on death of one of the SIPP holders. The first thing to note is that the SIPP policy ceases to exist, and the managing trustees will have to pay out the benefits either as a lump sum, which is tax-free if death happens before the age of 75, or if death happens after the age of 75, the beneficiary would have to pay income tax at their highest marginal rate. Alternatively, the value within the SIPP can be transferred into a new SIPP for the beneficiary. And again, any income taken from that would be taxed according to the age of death of the original SIPP holder. So this is what's allowed to happen. Let's have a look at the problems that we see with actually carrying this through when you come to looking at commercial property held within a SIPP. The first problem we see relates to the expression of wishes. So let's ignore the property for just a moment and we'll go on to explain what we mean. When you take out a SIPP, there's a lot of paperwork that you have to fill in, and one of the forms is called an expression of wishes form, which tells the managing trustees what you want to happen in the event of your death. Now, the most common wish is that 100% of the SIPP goes to the spouse on death. Now, the problem is that these expression of wishes forms are very rarely revisited or changed, and in most cases they're not fit for purpose. For example, if the spouse were to predecease the SIPP holder, it's very difficult for 100% of their benefits to be left to their spouse on death. Also, there may not have been children around at the time when the SIPP was originally created, so it's hard to actually do any form of planning with a simple one-page form that you're presented with when you're opening a SIPP. Another issue is the lifetime limit, which again might not have been around when the SIPP was created. And if the death benefits are put into a SIPP for the surviving spouse, then on their death, the combined value is now made up of 2 policies. And on their death, the combined value passing to the children might trigger an additional lifetime limit tax charge. So simply undergoing an expression of wishes review is actually a really important and valuable planning tool in itself. And of course, one of the things that's very often missed out is the fact that the expression of wishes can be changed at any time and can be rewritten and presented to the trustees. And of course, when you have a SIPP, there's nothing stopping you leaving a SIPP to your children on death so that they can draw down money, which is either going to be taxed or tax-free depending on your age at death. Another problem is that it's all well and good having the legislation that says you're allowed to do things, but actually the process of doing them involves a lot of paperwork. So we've got banking and transfers and legals, a whole bunch of things that are issues. So where you've got property in a SIPP or a collection of SIPPs, there's going to be a lot of additional costs. We're going to be talking about in specie transfers, and that means the property will be moving from the ownership of a SIPP into the ownership of the new SIPP, because they are completely separate legal entities, which in turn means that there's going to be issues with land registry, who are the owners of the property will change. There's also legal representation required, and some of the trustees require a solicitor to act on behalf of the beneficiary, as well as a solicitor to act on behalf of the deceased person's SIPP. There's also banking, because the bank account that money was paid into will have to cease, and if there's a new SIPP being set up for the beneficiary, that'll need a new bank account. And if you've got tenants paying rent, again, there'll be changes to the lease. So there's a whole raft of bits of paperwork and things that have to be done, and they're not free, and they don't immediately happen. So you can end up with a mess that can take 6 months or more to fix when you have property involved with multiple SIPPs and sadly someone passes away. So let's have a look at the planning proposal. First step is to establish a SAS. And of course, in this case, we have a husband and wife setting up a SAS, but at the same time, they have their son and daughter joining it. So you've now got a family trust where they're all members of the SAS. And then we do an in-specie transfer, just the once, of the property into the SAS. And yes, that will involve some planning and some paperwork. However, once that step is done, the SIPs go away and they no longer exist, and what we have is one trust, and it's a SAS and it owns the commercial property, just happens to have 4 members. The next step is that we look at the SAS and we look at the expression of wishes, and we sit down and we do some proper succession planning, and we define how much is going to be left to whom in the event of a death. And that's a very important process, because if the wife and the husband both have existing pensions value, what you don't want to do is to roll them up into one pot before they're passed down to the children. You want to actually pass things down to the children sooner. So let's have a look and see what happens in the event of a death when you have a family SAS that owns commercial property. We've got a death, and in this particular case, nothing happens, nothing changes. The SAS is still the SAS, it's still the same trust, and it's got the same bank account, nothing's changed. The rent and the gains are still held within a tax-exempt environment, and it's a simple internal administration process. If the expression of wishes required that a lump sum were paid out, then of course that can be paid out, subject to the SAS actually having cash. And again, that comes down to liquidity within the investments. Any rent that comes in on this commercial property comes into the SAS, but if that property is now held within a beneficiary's side of the spreadsheet, that money can be paid out to the beneficiaries tax-free, obviously subject to death happening prior to the age of 75. And once that's been locked in, any growth on their investment and any income taken will be tax-free, which is incredibly useful in terms of family planning. And of course, all other benefits accrue as normal. So the wife, she can be accruing her value, and again, in the event of her death, monies can be passed down to the children. And new members can join the SAS as well. So if there were minors who were under the age of 18 who didn't want to join the SAS, they can join the SAS, but if they were not wanting to join the SAS, they can join later and they can have benefits accruing to them from the rent that's coming in. So a family SAS is a very useful tool, and certainly goes a long way to solving the problems associated with having multiple individual SIP policies. The pensions legislation is still the same, it's just the practical application of the ownership and the holding of assets is a lot easier. So there you go, that was case study number 2, the benefits of using a SAS as a family trust and avoiding the pitfalls associated with SIPs and property holdings.